The allegations against Advocate Mpofu is that he brought an application in the name of Simbarashe Zuze, who the state is claiming does not exist. These allegations are not new. They were investigated by the Law Society of Zimbabwe and by the Law and Order section of the police last year. And the Zuze person was interviewed and they confirmed that he exists. So it's extremely surprising that now, suddenly he's being locked up for this. And secondly, as an advocate, really, advocates are there to bring applications when they're briefed by lawyers. And an advocate in the normal course, therefore, cannot just walk into court with papers that are his papers, because he has to be briefed by an attorney. And so really, the mind boggles how it can be said that he brought an application in the name of a person who does not exist. And secondly, the second charge is that he then plagiarized or used the affidavit of this non-existent Zuze, according to the state, to bring a second application in the name of someone else. Of course, when your case is dismissed on a technicality, you are entitled to bring the case, having corrected whatever technical faults the court perceived to have happened. That's perfectly, normal in normal day-to-day practice. And that, again, would not fall on the door of an advocate at all. And then, of course, thirdly, and most fundamentally, this prosecution is wrong on so many levels. Lawyers should feel free to represent litigants without fear of being arrested themselves. It is a cardinal principle in the practice of law that you should not identify lawyers with the cause of their clients. It is also part of the UN guidelines on the roles of lawyers that what you say in court, whether it's oral or written, you should have immunity from criminal or penal sanction, because it is understood that you are there to represent your client. Lawyers sometimes do get it wrong. Are we all going to be penalized if we cite a wrong section and it will say that we're trying to defeat the cause of justice by misleading the court? If that is to be the interpretation of the law by the state of Zimbabwe, then certainly lawyers will be unable to represent people. And for me, the most egregious thing about this is that two crucial institutions are involved. A supposedly independent prosecution department. That prosecution department is the one that's prosecuting Thabani for challenging the appointment of the prosecutor general. The Constitutional Court, which has a challenge before it where no decision has been made, is part of this. Where can people of Zimbabwe run to if they cannot run to the Constitutional Court for the preservation of their rights, where their lawyers will be harassed by the very institutions who are supposed to protect them?